So some key takeaways from this part of it. Again, the cases now are focusing mostly on issues of whether the person's qualified, whether they can perform the essential functions, whether the accommodation that's being requested is reasonable, whether the interactive process was handled in a fair way by both sides, and whether there's an undue hardship on the employer. Employees who don't disclose, as I just alluded to, their disability until after performance issues have arisen and are well documented are at a disadvantage. So employers who are documenting things well along the way are going to be able to show that they took reasonable steps. Employees should not wait until it's the day that they're going to be terminated or the day before to raise issues of reasonable accommodation. At that point, it's quite possible that it's too late. Employers who don't meaningfully engage in the interactive process or fail to follow established procedures on discipline or performance reviews are going to be at a disadvantage. So again, for employers, it's okay to have policies, but just make sure you follow them and they're applied equally across the board. And as I said earlier, the MCAD is still a good forum to bring most of these cases for plaintiffs, but they are slow.
And I'll just close with a few takeaways and then maybe take questions if there's any that we have time for. Hot issues, as I mentioned, effective communication at the time of arrest, both for people who are deaf or hard of hearing or people with psychiatric disabilities or autistic people. Service animals is another hot issue. It keeps coming up. We didn't have a chance to talk much about professional licensing exams and entrance exams, but people who need accommodations and taking tests in order to enter professions is a common Title II issues. And screening of individuals who have psychiatric disabilities as they enter professions that are licensed is another common issue. Community integration, as I just said, is likely to be really at the cutting edge of Title II work, not just the question of moving out of institutions or not being at risk of moving into them, but getting services in a meaningful, integrated way that allows people to spend days that are not just around other service providers and people with disabilities, but really to be part of the community like all of us want to be. And I guess another issue to flag for you is that some of the state law around bringing claims against public entities is less than clear. And so while you have some claims under the state public accommodation statute, there are benefits in this area of law, I think conceivably, about pursuing federal remedies. The third point here is what I mentioned earlier about the question of private entities that are delegated responsibilities on public entities. And then finally, I wanted to flag for you that the U.S. Attorney's Office has been probably more active than you might think in both Title II and Title III. And while things in Washington are in a state of flux, I think here in Massachusetts, the U.S. Attorney's Office Civil Rights Unit has been quite active. And so would encourage you, if you're filing administrative claims, to explore working with them.
So do you want to do the key takeaways?
Sure. So these are things that we touched on before, but just to underscore or underline these key points. Number one, internet-based services and programs are covered by the ADA as the First Circuit has interpreted, so we have that car parts precedent and then cases pursuant to that. Number two, communication access is a critical right under the ADA. It's certainly a major area, an issue that we see a lot of at the law center. And regrettably, or somewhat to our deep concern and regret, there continues not to be widespread compliance. So it's regrettably, and especially in medical context, medical providers, it's a continuing problem that we see. It's not gone away, despite the fact, as point 3 makes, that the ADA is 28 years old. There's really no good reason to remain non-compliant. We submit, it's been time to follow the law. There's no real excuse. One point that Caitlin and I wanted to make, and it's interesting because it applies exactly the same to physical access as well as internet or web-based access, and that's the point that it's always better and more cost-efficient to build in access from the beginning, whether you're talking about brick and mortar situation or web-based. So, for example, someone builds a building and they don't make it accessible. If they have to go back and retrofit it because they didn't comply with the access code, it's always a lot more expensive to do it after the fact. We had a case against a minor league ballpark, and they brand new, and they didn't make it appropriately accessible. When we prevailed in that case, they had to go back and reconstruct and rebuild it. Whereas the cost of building access from the beginning is just several percentage points of the overall cost. So too, when one is designing internet programs and services, that if you build in access from the beginning, the incremental cost is fairly minor, but if you have to go back and rebuild it or reprogram it, it's always substantially more money. Finally, this is a point really worth noting. People with disabilities can help with the planning and implementation of a client's access obligations and often can offer practical, effective solutions. In that ballpark case I mentioned before, the local disability organization went to the ballpark several times. Let us work with you. We want to talk to you. We can figure out the best way of affording full and appropriate access to your fans with disabilities. And quite frankly, they blew them off. They're, no, we're not going to talk to you. We're not going to talk to you. The first time the local disability organization saw it was on opening day, when they discovered, much to their shock and chagrin, that the accessible wheelchair seating was in the very last row of that ballpark. And they were picketing because they hadn't seen it. Had they been afforded a chance to share their expertise and background, that problem would have been obviated. So we folks who have disabilities can be a source of help, assistance, and practical solutions.